my earlier video, I explained what a big mistake it was for Tesco to call its innovative loyalty card scheme Clubcard. If you didn't watch that video, be sure to do so next. A better name than Clubcard would have been TESCOCARD. If, instead of introducing a new name like Clubcard, which wasn't ownable, Tesco had simply added the word card at the end of its own name, competitors would not have been able to call their loyalty cards TESCOCARD. That name uniquely belongs to Tesco. Adding the word card at the end wouldn't have made it free for others to use due to the wide scope of protection trademarks afford. If Tesco had named its loyalty card TESCOCARD, imagine what might have happened once Sainsbury's or another competitor wanted to also launch a loyalty card. Now, they wouldn't have been able to use TESCOCARD as a shortcut to explain loyalty card schemes. If they tried to say our card is similar to the Tesco card, that would have infringed Tesco's trademark. Tesco might have sued them for riding off their coattails. But even disregarding trademark infringement, would Sainsbury's or another competitor really want to highlight a competitor in this way? Informing your customers that you're introducing a card just like the Tesco card actually promotes Tesco. Some of your customers might just go to shop at Tesco's due to you highlighting Tesco's loyalty card scheme. That wouldn't be a clever move. So my message is that to be associated in consumers' minds in desirable ways, it's essential to use IP to get whatever advantage you can get when you're differentiating your business and making branding decisions. Clubcard is an example of what happens when you're not mindful of the brand protection dimension of branding when choosing names. Often brand consultants say they work with lawyers, but unless they involve a brand lawyer closely in branding decisions so they're informed of the brand protection dimension before finalizing their choice, they're not really taking account of the IP dimension properly. IP principles are part and parcel of business design. If a professional supports a business with its brand, whether by helping them to create a new one or to rebrand, learning about brand IP differentiates them from the pack in the branding industry. What people mean when they say they work with lawyers is that they involve a lawyer to search the trademark registers to check that a proposed name or design doesn't infringe on an existing brand's rights. I'm sure the agency Tesco used also worked with lawyers to do that. But when you work with lawyers in this limited way, you might avoid being sued, but you're not taking account of IP to make good decisions. If you've already chosen the name or branding and just want to check whether these elements infringe on someone's rights, you're just doing the most basic of legal checks. Supporting businesses with their brand, whether by helping them to create new ones or to rebrand, really does involve the need to learn about how brand protection impacts your decisions. Either work closely with a brand lawyer or upskill yourself in brand IP. After all, IP is one of the 3 disciplines that impact business design and branding. For a holistic perspective of branding, so you avoid scenarios like Clubcard from happening to a brand that you oversee, consider enrolling on my BrandTune program. I'll leave a link to it in the notes below.
Way to quickly identify resources area
Suitable for business owners, designers, marketers, commercial lawyers, brand managers, and founders to use to create effective barriers to entry and select names and other brand elements by which to uniquely stand out. IP is how you manage competition. In the next video, I'll explain the wider problems that arise when you choose descriptive names like Clubcard.